Is the Equal Rights Amendment actually about helping women? The answer is no. Let me explain. In 1923, women's rights activists, led by Alice Paul, pushed for an amendment to the United States Constitution called the Equal Rights Amendment, or the ERA. It was introduced to Congress, but failed. In 1971, the amendment was introduced once again, but this time it was approved by the House of Representatives and by the Senate a year later. Following the constitutional amendment process, the amendment went to state legislatures for ratification. In response, conservative women led the charge against the amendment, claiming it would not in fact help women, but it would harm them. Pro-family activist Phyllis Schlafly and others argued that the ERA would 1. Lead to women being drafted into the military, 2. Eliminate sex crime laws that rely on gender, 3. Alter laws which require men to pay alimony and child support, 4. Eliminate Social Security benefits for widows and homemakers, and 5. Force taxpayer-funded abortions upon all Americans. In the end, the ERA only received 35 of the 38 necessary state ratifications, leading to its failure. But now it's 2019, and the ERA is once again being pushed by activists. But this time, the movement to ratify the ERA in state legislatures across the country is not coming from those who want to give women equal rights, but from the abortion lobby. This is despite the fact that Alice Paul, the original author of the ERA, publicly called abortion the ultimate form of exploitation. So why is the abortion lobby obsessed with ratifying the ERA now in 2019? Because they are terrified that Roe v. Wade and Doe v. Bolton, the two 1973 Supreme Court decisions which made abortion legal in all 9 months of pregnancy, will soon be reversed. Out-of-touch activists now believe the ERA could help them worm abortion into the Constitution. So in reality, the ERA should be called the Everything Related to Abortion Act. Despite what you may have heard, the word abortion is not found in the Constitution because the framers who wrote the Constitution and the Declaration of Independence were fighting for the rights to life, liberty, and the pursuit of happiness. The last thing on their mind was taking those freedoms away. If the ERA was ratified, it would provide a constitutional cover for abortion. Don't believe me? NARAL Pro-Choice America, formerly called the National Association for Repeal of Abortion Laws, admitted to its supporters in a March 2019 email that, quote, "In order to protect our reproductive freedom today, it's essential we pass the newly reintroduced bill to ratify the ERA. With its ratification, the ERA would reinforce the constitutional right to abortion, which would require judges to strike down anti-abortion laws because they violate both the constitutional right to privacy and sexual equality," end quote. As new technology continues to develop, babies can now survive earlier and earlier outside of their mother's wombs. This new technology is making the trimester argument used in Roe v. Wade less relevant. But if the argument is instead based on equality of women, it wouldn't matter how developed the whole unique human baby is. Though it doesn't specifically mention abortion, if the ERA is ratified, it would lay the groundwork for this equality argument, which essentially says that women's equality requires reproductive and bodily autonomy, and without it, women cannot participate as full and equal citizens in our country. In other words, the abortion lobby believes that women do not have control over their lives unless they have the ability to end the life of another person, their child. In fact, similar equality language has been used at the state level to justify taxpayer-funded abortion. In 1986, the Connecticut Superior Court struck down a state law which banned the use of taxpayer funds for abortion using its own state ERA, ruling that, quote, "discrimination against pregnancy by not funding abortion when it's medically necessary and when all other medical expenses are paid by the state for both men and women is sex-oriented discrimination," end quote. And again, in 1998, New Mexico's High Court ruled that a policy to restrict funding for abortions violated New Mexico's ERA because, quote, "it resulted in a program that does not apply the same standard of medical necessity to both men and women," end quote. And let me be clear, the ERA isn't necessary. There are plenty of laws that ensure equal pay and equal protection for both sexes. The Equal Pay Act of 1963, the Civil Rights Act of 1964, the Equal Employment Opportunity Act of 1972, the Federal Minimum Wage Act of 1974, the 14th Amendment to the United States Constitution, the Comprehensive Health and Manpower Training Act of 1971, the Nurse Training Act of 1971, the Higher Education Act of 1972, the Comprehensive Employment and Training Act of 1973, and the Federal Equal Credit Opportunity Act of 1975. You get the point. So the next time you hear activists pushing for new laws ensuring equality for women, Ask them why the current ones aren't enough. You'll get your answer. The ERA isn't about women's equality. It's about pushing the agenda of the abortion lobby.